Welcome back. You're watching Newsx. I'm Rishabh Gulati. We try to now navigate with a lot of responsibility and purpose one of the most complex and matters of seriousness and gravitas that I can say that I've had to sit here and have a conversation from. So I've been drawing the premise through the course of the afternoon. There is a vacuum of information. Vacuum of information does not necessarily mean that nothing is happening or nothing has happened, but it does mean that we have to take a little bit of care given the seriousness of what's on the table to not speculate too much, be reasonable with what needs to not take place, but also at the same time not understand that yes, we are going to have to now have serious conversations on what is in a sense a very serious subject. These serious subjects that are taking place come from rulings that are coming our way. Ladies and gentlemen, how we perceive the definition of the law as applied versus our understanding of the definition of law needs disaggregation. So now you've seen a ruling which has come from a high court in its interpretation of the definition of law, that a certain act tantamounts to what is rape, and a high court is being asked to understand the law in finding the line between aggravated sexual assault and rape. So we will have to understand where that line is as far as the law is concerned, therefore understand the reason of the judgments that have come our way, or what has been written in the judgment that has come our way, and then align ourselves with a conversation on whether that is a satisfactory interpretation of the law, or is it open to appeal, or B, in fact, if indeed the law is not sufficiently disaggregating this well enough, and therefore we have to revisit the law. Let's open up this conversation. Brinda DK with us, Sanjay Sahay joining us on the broadcast, Mr. Napinai is joining us, he's a senior advocate, and Vineet Jindal, who's also a lawyer, joining us. Let me set this up, if I can, with Mr. Napinai. So what, in this case, what is the understanding of the difference between aggravated sexual assault and something worse, which is rape or attempt to rape? Ma'am.
Rishabh, first off the bat, let me start off by saying, is this judgment fallacious? Is it wrong? I personally believe yes, it is. So with that out of the way, let me just clarify, and pardon me if I get a little technical, but the issue before you is when and how does an assault become rape? And we are naturally talking about a sexual assault here. And in this particular case, the issue was about attempted rape and not just rape, and also of aggravated sexual assault. And that's where I believe the court has gone wrong in assuming it is either or, instead of understanding it could be both. And it is also critical for the court to understand, and here this is absolutely fundamental, and this is something that's taught to us in law schools, and we should not forget our fundamentals. And therefore I would take the liberty of mentioning something that's very tried for us, which is what exactly amounts to an attempt, and that's involuntary or pure volition. If you have been unable to commit the crime, then that's an attempt. So in this case, the facts that the judgment itself sets out clearly says that X number of people attempted an act, and then other villagers intervened, and then they threatened them and ran away. So it is not like they stopped themselves from committing the act, they were stopped, and therefore the attempt part is clearly made out. To say that it's preparation is actually diluting the intent and purpose of the law, and the law has been reiterated time and again. The Verma committee pointed out why these laws are needed and then expanded it further with additions. The law on rape itself was modified to ensure that certain acts which does not only amount to penetrative sex will also be rape were included. All of this then gets negated with a judgment like this. So in short, if you ask me, yes, in this case, the very acts of the accused tantamount to an attempt to rape and also aggravated sexual assault. You could also add other offences which the court seems to have put down as minor offences. But the criticality here is you start off with what is the major offence and you're at a preliminary stage. You wait for a trial to be conducted, evidence to be recorded, and then decide where exactly the facts place the case. This is such a premature situation, and to intervene at this juncture with these kind of comments that you see in the judgment is absolutely uncalled for, and I would say it exceeds the remit of this particular jurisdiction.
All right. Brinda Adige, your thoughts?
Agree. Sorry.
Yeah, we can hear you, ma'am. Go ahead.
Yes, I completely agree with our first panelist. She has very, very clearly explained and reasoned out why this judgment, this order, whatever anybody wants to call it, is not only fallacious, is unacceptable within the ambit of law. This cannot be called interpretation by the judge, because the judges in High Court and Supreme Court have this power to interpret something. Now, yesterday also I was talking interpretation or giving a larger meaning and connotation to that law or to that phrase is to aid that particular case, so which may for some reason in letter or spirit has not been conveyed in that law, is to then interpret and say, and so hence it also means all this, so that it talks about the seriousness, the gravity, and the importance of that particular aspect. Now, what this judge has done by making a statement like that is to trivialize sexual abuse, assault, and rape. All of it, like Madam pointed out, is not either or. It seems to be coming either before or after. Now, why would somebody want to look at it like that? Is it because it is just a patriarchal mindset? Is it because he was trying to be talking about more the letter of the law and what must be the sections that the police have forgotten or have missed out or have been unprofessional in putting it down? What is the reason for making such a statement? Because such a statement sends out a wrong message. It has set a precedent. And these precedents will be also there argued by defense lawyers in future. It is not something that's going to get wiped out unless the Supreme Court says strike it off.
So let's address it for a second. Sanjay Sahai, again, what are your thoughts on this? Because it's a difficult one, that there is a letter of the law versus the spirit of the law. In this case, two people have suggested that both the letter and spirit here actually point to the same conclusion, that if you've caught a girl, you are attempting to disrobe her, you have the attempt to or have the intention of raping her, and because somebody intervenes and prevents you from doing so, does not mean that an act of rape was not under progress. What's your thought on this?
See, we're talking about letter and spirit, and I think the letter and spirit are very, very clear and post Nirbhaya. Whatever amendments came to the definition of rape, I think if you see it through that prism, it is certainly rape, it is nothing else. Now, there are two things which come to my mind, and the court has certainly erred in a very big way. First, he says that it did not meet the threshold. What is that threshold? What are the legal parameters of that threshold? Are there any judgments to that effect? What citations he has to put? Nothing is there. Second, he says that evidence that act had progressed beyond preparation. If this is not beyond preparation, then what is beyond preparation? I have absolutely no idea. So this is pure black and white. I don't think we are in a gray area. And I have been repeating over and over again that from a district judge to the Supreme Court of India, if the basic law is not being interpreted in the manner it should be and in the overall frame of things, see, spirit is letter, and spirit does not mean that you take out the letter and there is some spirit. And that spirit is not something which lives on its own. It comes out of the letter which is all around it. So this whole concept of letter and spirit being not in tune, which is, so primarily what you are saying that the letter is different and the spirit is different. Certainly that is not the case. When the law is codified, and most of my panelists, all the panelists would agree with me, so it is codified in a manner that the spirit is carried on. And in case there is some comma, full stop missing somewhere, I think that is also taken care of. So where you are saying that attempt itself is not there, and Advocate Napinai has explained it with all amount of clarity. As to you are missing out on the rape, you are missing out on the attempt to rape also. Then what is this offence?
Okay.
Then there is no offence made out. Then tomorrow you will miss out on the aggravated sexual assault. Because today if I ask whosoever, that is what is aggravated sexual assault, I don't think any investigator in this country can tell you 1, 2, 3, 4, 5. So you are sitting here because you have the acumen to understand law, to implement law, and any stakeholder in the criminal justice ecosystem, if he errs anywhere, to set him right. If that is not happening, we will keep on debating till the time called home. And how many interpretations, how many citations, how many how many judgments will come?
Okay.
And if from a district court till the Supreme Court of India, if blatantly judgments come which says that it is antithetical to that particular law, the ingredients of the law, and comes over and over again, what action is taken against the judge? So I can give any judgment at the district court level, and after 4 years down the line, the Supreme Court it makes it null and void. It gives a separate judgment, and I am fine, and Supreme Court is also fine. Is it as a part of the same judicial administration of this country? See, I am forced to speak this today.
Okay, hold your thought for a second.
Finding things adding up in the manner it should be in the judicial administration.
Let's get a perspective of Vineet Jindal. Mr. Jindal, what are your thoughts?
Definitely, the judgment is very disappointing in respect of law, even because we all know, when being a law student, there are two specific things which is required when we are talking about criminal law. One is intent, and the other is act. Intent is very much there when the sequence of their attempt, what they have doing, that is there. That how they are pushing the girl, how they are overpowering the girl, how they are molesting. Even they are going forward, and they are stick has been broken by the accused, and the intent is also been there. So what is left? I think the High Court judge has been missed the basic parameters to find out any kind of law, the act and the intent. In this judgment, this has been I think as the constitutional power is there with the judge of a High Court, I think they have misinterpreted the judgment, the law, and he has also been forgotten the basic principle of law which has been studied in the law colleges. So I am also not agree with this thing, and I stated by one of the panelists that this is the very initial stage. It is a stage of framing the charges. The allegation is there, investigation has been completed, but this is unwanted intervention by the High Court judge by calling this kind of specific findings, which is not required at this point of time. And I am also not agree with the judgment.
Okay, all right. So we have consensus. Everyone thinks that in a case like this, where somebody is or multiple somebodies are grabbing a girl, trying to pull her into enclosed space, trying to disrobe her, molesting her while they're doing this, that to suggest that this was not going to eventually end up in rape had other passers-by not intervened, or inferring a suggestion or leaving that suggestion room for interpretation, is not good in law. It's not setting a good precedent. Now, then the question then begins is, our conversation here is an empty conversation. We can just talk about it. Ms. Napinai, then what is the recourse available if the consensus is, and so many people who are ministers and activists and members of parliament and you advocates are saying the same thing, other than saying what can actually be done to have this amended, corrected, changed, appealed, reviewed, what can be done?
Well, the first and foremost is it's definitely open to the state to appeal this judgment, and I would earnestly request that they do so. And alternatively, the Supreme Court also could take suo motu action in this case. You have had instances like this earlier also, which shocked one's conscience. If I were to give you an illustration off the cuff, the skin to skin judgment on when exactly will it amount to sexual abuse, right? You remember? And the Supreme Court did step in and set things right. So here is yet another judgment in which their intervention would be warranted.
Okay, so if it does go to appeal, I'm assuming there's no recourse for the present situation, because the judge has ruled. He can't say, okay, in retrospect I've changed my mind.
There is a provision of review for each court, but the review powers are very restricted.
So the effective way is to actually appeal this and improve upon it or correct it as is being done. Brinda DK, then does that brings us then to the larger question is that the attempt to rape, which is what would have happened, this girl would have probably been a rape victim had it not been the coincidence of somebody either seeing her struggle or hearing her cries who happened to be nearby and was in a position to intervene and successfully intervened. We saw another case in Karnataka very recently in the case of 2 foreign tourists, where an individual who tried to intervene was in fact himself murdered and thrown into a canal. So it still seems to be an assumption among some people that you can commit rape and potentially get away with it.
Yes, that is the message or the ruling that people like these judges are giving. And we are still harping and hemming and hawing about judicial reforms. For some reason, we don't seem to want to question the judiciary or the judges. There is no performance evaluation of the judgments given by certain judges, saying that if 5 such judgments are given in a given year, then this judge has to be transferred or this judge has to be put away somewhere. Even today, we hold them like gods. And that is unacceptable, because continuously the government is bringing out a lot of laws, a lot of schemes and campaigns, Beti Bachao. And when you have a judiciary like this, where is there going to be any Bachao? We are talking about prevention. After that, we will talk about protection and then the prosecution. But if we are unable to prevent because of these kind of statements and mindsets from people who are supposed to bring perpetrators to justice, if this is the kind of talk that comes over there,
okay,
the mindset is I can get away. I am not going to be punished.
Okay.
Then what is the point of
Okay,
rule
so
of
for
law?
people watching the broadcast, yes, the judgments of sitting jurists at a high court level or district court level are reviewed at the time when a decision is to be taken for their elevation. So is that a transparent process? Do we know about why the decision was taken? No. But does the collegium look at judgments? Yes, they do. But the question then is, and Mr. Sahai, why are we then also assuming that this judgment is delivered in bad faith? Is it an erroneous thing, a mistake that has happened, or should we then assume that this was in bad faith, that a bad precedent was set in bad faith? Why isn't that a bit too much also?
If a judgment is erroneous or it is delivered in bad faith, it finally comes to one and the same thing. If it is erroneous, it speaks very low of the legal acumen which a person, a judicial presiding officer at that level should have. And if it is done in bad faith, I think it is even worse. If it is a combination of the two, which also might be the case, which that proposition have not given to me, that also might be the case. So what is the outcome or the impact of it? I think I leave it to the judgment of the panelists and anybody in the country. My understanding is very one and simple thing, where we say minimum force to be used in the police, and if firing is done where it is not required, then what do we do? I will not tell you what action is taken, I am just leaving open questions. My understanding is that the judges in this country, and I will start only with the district judges and additional sessions judges till the Supreme Court, are they all on the same page? And if they are not, We require a 6 months to 1 year training so that they are brought onto the same page and so that they are evaluated and told very clearly this is a constitutional court, non-constitutional court, all those issues are not getting. You are sitting in judgment over an 11-year-old girl who faced this particular thing, shameful as it may be, where the police has failed, the society has failed, literally everybody has failed. And a judge in a very armchair manner delivers a justice, brings down the gravity of the crime at a point where he is not supposed to intervene. It is primarily, it should be a mechanical administrative order.
Okay. All right. Hold your thought. Let me get Ms. Napinai back in. Ma'am, is that the premise then, that everybody needs to be on the same page? I think that's the sentiment that Mr. Sahai is suggesting.
It may seem a little utopian, because you have to remember it is not like training is not being imparted. At a time when you are made part of the system, you are subjected to not just one but continuous training processes, and these include sensitization sessions also. What you take away from it is what matters. Unfortunately, the stage at which social engineering starts is from your youth, and your bias then carries over to the bench also. So that bias is what these training sessions are meant to take away. So the initiative is there from the judicial training session process, but how much is really being carried forward is something that each individual will have to speak for and act on.
Okay, I have to address the larger question before we conclude, ma'am. How do we now know whether all the efforts that have happened in terms of the framing of the laws, in terms of the judges and judgments and the rulings, and in some cases in the recent past we've had death penalty that has actually been executed, that after doing all of that, I don't know whether we are seeing a dent in any of these cases or not. It doesn't seem like it.
Of this case, I don't hear anybody speaking about. After the Verma committee report, one critical provision was included, 166A, which said that if a police officer fails to register a complaint, which includes for rape, 376 and few other provisions, then the police officer can also be held liable. In this case also, the mother had to go to a magistrate for the case to be registered. Why I am mentioning this is, what Brinda said is critical here. We have to show that, it's not enough to show that we have laws. We have to show that these laws are effective and that they will come into play if you violate it. You mentioned about the Karnataka incident, which again shocks one's conscience. When and how will something act as a deterrent? At the time when I'm thinking about committing a crime itself, if I believe that I will face the consequences for it, then probably, not always, but probably it will act as a deterrent. So that deterrence, I feel, is still very low when it comes to rape and gang rape cases. Unfortunately, that is the reason why a criminal thinks he is emboldened enough to share evidence of his crime online, and that's why you actually had rape and gang rape videos being uploaded online. So if that's the level of fear that a criminal has,
or lack thereof,
then the system fails.
Okay, Vinny Jindal, what do we do then? Because I assume that this is going to go to appeal, and yes, I understand that yes, the sentiment is that people should be on the same page from where the law is being drafted to how it is being interpreted, not just at the Supreme Court level but down to the district judge. But as upset as some people might be with the tone and tenor of the judgment, the bottom line is there are still a bunch of people who think they can easily do this and easily get away with it.
Yes, law and the judgments is also made for the society, and the message should be given to the other persons who has been, the way you are talking about the persons who has been talking about, and they can think that they can do anything and then get away. So the judgments is also send a message to the society. I think judicial reform, which we have talking since long, that is a desperate need of judicial reform. Rightly stated that the evaluation of the judgments should be a specific time schedule should be there for the all judicial officials from the district to the Supreme Court, whosoever. I think it should be needed. Time should has been come. The judgment should be evaluation should be done. There's some committee and some kind of structure should be developed for the scene of the judgment, whether it is passed appropriate by the appropriate
Okay.
laws.
So we-
and the,
so-
all,
so,
all
I mean, I've been having these difficult and painful conversations since I began this job, better part of 20 years ago, and it doesn't seem to be saying that we are either preventing crime or indeed imparting justice more effectively if we are still stuck. Now I know there are no overnight solutions, but surely we can't be in a position where it's day to day. I mean, just imagine there are a group of inebriated men walking by, they spot two women and they assume that it's a crime of opportunity, that we can get away with it, and if somebody intervenes we can just murder that person and throw them into a canal, and there is a percentage chance that nobody will ever find us. We are stuck. Now sometimes the policing fails because not enough evidence is gathered. If example your case is not registered, what medical report will you do 10 days or 1 month after the fact? Then therefore there is not enough evidence for conviction. Then indeed when an evidence is being tried, we are seeing interpretation of the law as it exists in a manner which there seems to be consensus is not in keeping with what has happened. We are in a bit of trouble. We need to constantly be working on it. It's pretty depressing. I thank my guests for at least trying to have this conversation, difficult one that it is. Think of it, little girl, two guys dragged her and were trying to rip her pants off, okay, and then somebody intervened. That's what I mean. Her crime seems to be is that she was not raped, and therefore can't prove it that this is what these guys were trying to do. That is a horrid thing to even imagine or to explain. Take a break. See you in a minute.